Hi, everybody. Welcome this afternoon. It's nice to see you all here with us. I hope you're all staying cool. It's really nice to see you all again. My name is Kara McDonald. I'm the Director for Philanthropy and Plan Giving at the Seattle Public Library Foundation, and I am joined by Jessica Carso-Bouillon, the Interim Director of Donor Relations at the King County Library System Foundation. Our organization's partnered way back in 2020 to offer these free webinars, and I don't think either of us knew just how popular they would become. Since we started these, more than 6,000 of you have signed up to learn about wills, estate planning, and how you can support your library through your legacy. These are all topics that are definitely on people's minds, and we're so pleased to be able to offer you this free resource to help with your planning.
Hello, everyone. Thanks, Kara. It's really wonderful to be back with everybody, and thank you for taking some time on this sunny day to be with us. Before we get started, I just want to take a few moments, a very brief few moments to do some housekeeping. One of the most important honors that I have is to remind all of us that no matter where we're joining from today, where we're literally seated is on Indigenous land, the ancestral homelands of all the tribes and bands of the Coast Salish peoples, including unceded territories. And we do honor both the land itself and the original caretakers who are still here and very active today. A little bit of housekeeping, and we are incorporating some of this housekeeping in the slides. So if you do log in, if you decide to join us again for one of our next webinars, if you log in again, you'll see some of that to help. We know that we're all trying to be really old pros now at this Zoom thing and this technology thing, but we do want to remind you of a couple things. Number one, we are recording this presentation, and after the presentation, we both, Kara and I, will send out the links and follow-up emails to you so you get all the goodies at the end of the webinar. The very important piece to this is a lot of you will have questions, especially during Tiffany's conversation with us. It's really important to put your questions, into the Q&A button, not the chat. That way, Tiffany will see it. We're all monitoring all of these buttons, so to speak, but Tiffany will be zeroing in on the Q&A. So please be sure to put your questions there and not in the chat. Tiffany does not have a chance to do her presentation and monitor the chat. If you have a question, and a lot of times this happens, you have a question that somebody else has answered, you can upvote the question by using the little thumbs up sign. And that really helps so that we can see how many folks have a very popular question, and we can try really hard to get to those before the webinar wraps up. We do really take your feedback to heart. And so at the end of the webinar, don't sign off, watch the action that you will already automatically be prompted to take a very quick survey. It will just take you a few moments, but we promise that we have really been taking that feedback to heart and then making those improvements in these webinars. And what will happen there is we try very hard to sweeten the pot. So in addition to your feedback just being really valuable to us, if you do take the survey and you complete it, you're entered into a drawing automatically to win one of two prizes: bags filled with books. Again, I know that I'm automatically disqualified, and I say that every single time we're doing this, but to me, that is an optimal prize. So do take a few minutes to do the survey.
Yes, thank you.
And Kara, back to you.
Yes, thank you. Well, I'll invite Tiffany to join us on screen now. Today's webinar is the second in our year-long series curated by estate planning attorney and library lover, Tiffany Gorton of KHBB Law. Tiffany is a partner there, focusing primarily on trust and estate litigation and tax and estate planning. She's hosted many of our webinars already, and we are so thrilled to have her this entire year to share her extensive knowledge with you all. So Tiffany, let's talk about the probate process.
Thanks so much, Kara, and thanks to you, Jessica, as well, and to all of you for tuning in this afternoon. This is probate in and of itself. The word may cause some feelings to come up, some thoughts, some ideas, some questions. It is no surprise that there are so many of you that logged in today, just given the fact that it is a word that we all hear. And I'm here to kind of demystify it a little bit. because I do think that probate does get a bad rep to some degree. And so let me ask a question, and then let's go ahead and dig in and kind of maybe dispel some myths. And I think you might be surprised today. So first off, just answer this in your own mind. Do you think you should avoid probate? That's question number one. And the second question is, why or why not? Just in your own head. What are your thoughts and ideas in this very moment with respect to those questions? Now, let me go ahead and start the myth dispelling, so to speak. In Washington, probate is not a bad word. It's not a 4-letter word, and it's not a bad word. It's okay. So like I say, it does get a bad rap. And I think that if you look at this from a national perspective, there are definitely some states where probate is expensive. It is a drawn out process, and it is to be avoided. It is not the case in Washington. In Washington, the probate process is not particularly onerous. States like California, everyone wants to avoid probate. I'll tell you why. In that state in particular, the expense associated with probate is directly related to a percentage of the assets. That's how the attorneys get paid there, which is not wrong. It's just that is what their system looks like. And so that is one reason that folks want to avoid probate if they're California residents. Second, it's a bit of a clogged system and can take a significant amount of time to move through the process. Whereas in Washington, the probate process, again, is not onerous. There's no percentage of assets paid to attorneys or anyone else. So that expense is not incurred. And the time frame is actually somewhat fast-tracked, so to speak. There are certain things that have to occur. Now, probate can take a longer time than maybe you would like. It doesn't happen overnight, but depending on the tax requirements, so the tax filing requirements can extend that. And we'll talk more about that here in a little bit. But just as a general rule, having a probate in Washington is not the end all be all in terms of what you should be trying to avoid. Probably 9.5 times out of 10, my clients, regardless of shape or size, are very well served utilizing a will as their primary planning tool and having a probate or an estate administration after death. One other kind of myth, so to speak, or maybe not myth, but maybe a common misconception is that if you avoid probate, meaning you utilize typically a revocable living trust as your primary estate planning tool in order to avoid probate, that there's going to somehow be no administration or no expense after death. And that's not true. To some degree, we're comparing 6 of one, half dozen of the other, because what happens when someone dies, regardless of if they have a will, their estate is intestate, which we'll talk about more, meaning they have no planning, or they have a revocable trust, there's going to be some administration of assets to some degree, most of the time. So there is not, it's not really a choice of avoiding probate because you don't want to do the administrative steps. It is, do you want to administer an estate through probate, or do you want to administer a trust through trust administration? And as we'll see here, those steps look very, very similar. So with that, I'm going to share my screen and talk about some slides, and share my screen so you can see my slides. And these will be shared with you after the presentation. And also feel free to include questions in that Q&A box as we kind of move through this, so to speak. Okay. One other quick note is with respect to the probate process. If you are either going through this process, you know someone who's going through this process of either estate administration, which is also known as probate, or trust administration, depending on what tool the deceased person used. This can be, it can feel overwhelming. And I just want to remind folks, or kind of keep this in mind for the future, if you do find yourself administering someone's estate, that you're not required to overnight become an attorney, an estate expert, a CPA, a financial advisor. I know sometimes folks can feel a little bit overwhelmed because you're dealing with someone's assets that are unfamiliar, you're also grieving because you've presumably lost somebody important to you. So there's a lot of those kind of layers that are feelings related, not necessarily just, legal issues that are associated with this. And so what I tell my clients, what I will tell you, and I hope that you'll share this with anyone that you know that's going through the process, is give yourself some grace, because it is a lot. There are a lot of tasks to do, but it's okay that it feels like a lot of tasks. That's because it is a job, and sometimes it can feel like a full-time job. But in any event, it is something that we don't all, unless you're a trust and estate attorney, you're probably not doing this more than once, maybe twice in your lifetime. And so it can feel like new territory, so to speak, because it is. Now, kind of thinking through that, what is probate? So it is the court supervised process of settling a decedent's, a deceased person's estate. So basically settling debts and transferring assets of that deceased person. And again, whether it's a probate or a trust administration, really what you're doing is kind of gathering assets, seeing what this deceased person owned, real estate, investment accounts, retirement accounts, life insurance, bank accounts, interest in businesses, all the things that we own as individuals. You're looking through this lens into this deceased person's world and saying, okay, what did this person own? And you're taking those assets and getting them into kind of the correct buckets, directing them according to the roadmap that the deceased person has left, either your will or a trust, or potentially, just Washington state law if they didn't have a plan. And you're making sure that you're settling their final affairs. So if you think about it, you can think about it like a business. If you were winding up your corporation or winding up your LLC, it's kind of the last time that you're going to administer, write checks, file tax returns, take distributions, etc. You're kind of closing up the business, so to speak. It's a lot similar, if you think about it, to kind of closing up a business. Now, what happens in the probate process is kind of soup to nuts. You file the decedent's will with the court if they had one. If they didn't have one, then you ask the court under the laws of intestacy to appoint you as the personal representative, which can also, sometimes that person's called the executor, sometimes they're called the administrator. But basically, this is a court supervised process of buttoning up all of the decedent's assets, paying their debts, ultimately transferring the assets to their rightful beneficiaries as either designated under Washington law or under the terms of the decedent's will. So again, kind of gathering assets. You're going to also notify and pay any associated creditors, file any tax returns and pay any taxes that are due, and then ultimately distribute the decedent's assets according to the terms of the will or the Washington law. So what does this process kind of logistically, what does it look like? Because this is, I think, where, we can think about it in terms of an idea of, okay, here's a nutshell of what the probate process is, but what does it actually look like when this happens? So I'll kind of break that down on a very basic level for you so that you can think through kind of each of the steps and kind of picture what that might look like. So what happens when a person dies? Within usually a week or so, a death certificate is going to be issued. And that's important because when we open probate with the court, we have to give the court two things: a will, if it existed, and number two is the death certificate. This is anecdotally, several years ago, there was a probate opened for a person who was not deceased in some other county. I can't remember which. But that is improper, as you can imagine, because the person was still living, so there should be no probate for them. So as a result, the court is very much a stickler now in having the death certificate on file. So when you're opening a probate, you file the will, you file the death certificate, and then you file a petition basically saying, hey, court, the will appoints me as the executor, or if there's no will, I am the person under Washington law or a person under Washington law that's eligible to serve. I would like to serve. Please formally appoint me. And what the court does then is they sign an order. And that order says, I appoint Tiffany Gorton as the administrator, executor, personal representative of the estate of Mr. Smith, so to speak. And then the court issues what's called letters testamentary. And what those letters testamentary are is a one-page document that the court basically provides that says, Tiffany R. Gorton is the executor of the estate of John Smith. And that document gives me kind of the keys to go to banks and say, hey, bank, I need to get bank records and make sure that I know about this deceased person's accounts. Hey, life insurance company, I need to know if there was a policy owned by the decedent on the decedent's life with your entity. Selling real estate. A lot of times, as you can imagine, when someone dies, they own a house. Being able to list and sell that property or otherwise transfer that property to beneficiaries if folks want to own the property together or receive the property as is versus receiving proceeds from a sale. The letters testamentary give the world notice that I, Tiffany Gorton, in this example, have the authority to do that. I have the authority to sell things. I have the authority to transfer things. And I have the authority to execute a deed when there is a potential buyer for this particular piece of real estate that was owned by the decedent. So what happens after that, once you're appointed, the court has signed that order and issued the letters testamentary, then it's time to get to work. So as you can imagine, there is, think about your own house. Think about what would happen if something happened to you. Somebody has to come in, the executor, and go through the tangible personal property. Make sure that if you have any valuables, et cetera, that your heirs or your beneficiaries under your will have an opportunity to say, yes, I do want, grandma's cookie jar or the family, long-term family holiday decorations or, grandma's pearl necklace, the family china, anything. I've had folks that, are musicians and not necessarily professional, but their instruments or their guitar picks, things like that are important to the people who love us, those types of things, making sure that all those things are accounted for and can be distributed. Now, oftentimes, as you can imagine, there aren't a lot of, not everyone takes, not every beneficiary takes all of the tangible personal property from grandma or grandpa or mom or dad or whomever the decedent is. We don't fill up our houses necessarily with those things, but having a few things that are important is nice. And that occurs in most probate administrations. So what happens after the things that are of sentimental value or even of not dollar value are distributed to beneficiaries? Well, then there still may be some things, clothing, household goods, furniture, all the things that are in someone's house. So that executor is tasked with, if it is worth the time and the expense, maybe hiring an estate sale company or listing certain things of value on Craigslist, selling those items, putting the proceeds therefrom in the estate bank account, which they've opened because that's part of the process. Making sure that, all of those things are taken care of. If there are valuables, like the person had an art collection or coins or, things that are of more value than, my used couch in my house, my personal house, anything like that, an appraisal should be obtained. And then, dealing with a professional dealer in art or jewelry or, whatever the item may be, making sure that the appropriate fair market value is received for those items. So that's the tangible personal property. This is in addition to cleaning out the refrigerator and doing all the things that would have to occur if somebody died. So from there, making sure that all accounts are accounted for. So sending correspondence to, looking at the decedent's mail, looking in their filing cabinet, looking in their records to see, okay, Tiffany banks at Chase Bank or at the, Boeing Employees Credit Union or whatever the, financial institution is, making sure that we identify all of the decedent's accounts, bank accounts, savings accounts, checking accounts, investment accounts, retirement accounts, life insurance, all of those things, making sure that those are all accounted for. And a number of them may have associated beneficiary designations. And so that really brings me to what are probate assets and what are non-probate assets. So non-probate assets, just kind of taking a step back here, are going to be any assets that are titled as joint tenancy with right of survivorship. Oftentimes this is a checking account or other financial account can have titling like this. Property that's subject to a community property agreement, meaning husband and wife, or two spouses rather, have entered into a community property agreement. Oftentimes what that community property agreement says is all of our property is community, and when spouse one dies, the property should go directly automatically to spouse number two. Now that's effective as between spouses, but it doesn't transfer property to children, to heirs, to charities, to other beneficiaries. It's only as between spouses, but it doesn't, it would qualify as a non-probate asset. So for example, my husband's name is Nick. So using him as an example, something happens to me, if Nick and I had a community property agreement that said, upon the first death, all the property transfers to spouse number two, and then I die, well, then Nick is vested with the property as spouse number two, the surviving spouse. But say, for example, then something happened to Nick, that community property agreement doesn't provide for distribution to other third parties. It's just between spouses. Property held in trust is going to be not subject to probate, maybe subject to trust administration, which we'll talk we're talking about a little bit already, and we'll continue to talk about that. But so, for example, sometimes assets are transferred to trust, like a life insurance policy, for example, is transferred to a trust during the person's lifetime. Then at death, that life insurance policy is not going to go through probate. It's going to pass under the terms of the trust. Similarly, a life insurance policy that designates a beneficiary. So say I have a policy on my life and I designate my husband, Nick, or shameless plug here, I designate the Seattle Public Library Foundation or King County Library Systems as a beneficiary. That asset, that life insurance policy, doesn't go through probate. It's going to be passed via contract automatically because it's a quote unquote non-probate asset. It has a beneficiary designation with it. Similarly, transfer on death accounts or pay on death accounts. So again, bank accounts, investment accounts, retirement accounts, any type of an account that has a beneficiary designation associated with it will pass via that contract, that beneficiary designation, or that joint ownership with rights of survivorship, like I mentioned at the very top there. Those will transfer automatically. And what happens in terms of the administration for those assets is the beneficiary will provide a death certificate to the financial institution and say, hey, I'm the joint tenant. I have rights of survivorship on this account, or I'm the transfer on death beneficiary for this account, or the pay on death beneficiary for this account. Please transfer that account to me. And then there's, an internal process that each financial institution will go through, but it's not part of the probate. Now, when it can become part of the probate, and why I say that as part of the executor's job, they need to make sure that they're kind of accessing all the assets and figuring out what the decedent had, including accounts, et cetera, is sometimes folks don't include a beneficiary designation on their life insurance policy or on their bank account or their investment account or any number of things. They don't include a beneficiary, or they include my estate as the beneficiary. Well, in those circumstances, me as the executor, I need to know that those assets exist, that those accounts exist, that those policies exist, because if there's no named beneficiary, or if the estate is named as the beneficiary, then it's part of my charge as the executor to make sure that those assets get administered and passed according to the terms of the will or the laws of intestacy, depending on if the decedent had a will or not. Now, again, we're talking about probate and estate administration and basically getting all the assets to the right recipients as kind of part of this administrative process. And it can be true for assets under the terms of a will, or sometimes assets under the terms of a trust. Okay. And so let's talk about the differences of those documents. And there are differences, but in the administration process, there are also a lot of similarities. So a will is a document that becomes effective at death. So if I execute a will as my primary estate planning tool, I'm going to basically provide under that will a roadmap for distribution of my assets when I die. It's going to appoint an executor or personal representative. And again, that person gathers all the assets and distributes everything according to the terms of the will. That will gets filed with the court, and then the probate's opened. Whereas a revocable trust is something that is to some degree active during life. But again, it also provides a designation of a trustee instead of a personal representative. So some other person that is going to administer the assets of the trust when I die. That's the trustee in trust terms. It's going to hold title to my assets, meaning during my lifetime, rather than dying owning my house as an individual, I would transfer my house to the name of the trust. And so then at death, the trustee administers the house from the trust under the trust administration versus under a probate administration. So again, I say that sometimes the steps are the same. So to some degree, it is 6 of one, half dozen of the other, because there are some steps that are the same. Just by having a revocable trust, transferring my assets to it during life doesn't automatically mean that I die and my trust beneficiaries wake up suddenly having title to my house. There's still some administration that has to happen under the terms of the trust that's very similar to what happens in a probate. It just doesn't involve a court necessarily. So let's talk about a few common terms. Now, you've heard me say testate or intestate. And again, what this means, testate is when a person dies having validly executed a will. Intestate is when a person dies and they didn't execute a will, they don't have an estate plan other than what the laws of intestacy here in Washington provide. So in either of those circumstances, a probate is typically going to be required, because if they have enough assets or if they have real estate, we're going to need to go through that administrative process to make sure that their final income tax return is filed, potentially an estate tax return. We'll talk about those in just a minute. But basically, we need to gather their assets and make sure they're distributed properly, regardless of whether they had a will or they died intestate and we're following Washington law. Again, a personal representative is going to be the individual or individuals that are appointed to administer the estate, also known as administrator or executor. Letters testamentary, we talked about, that's what the court issues when the personal representative / administrator, et cetera, is appointed. That gives them the power to deal with all the assets. And what's a testamentary trust? That's one we haven't talked about yet, but it's important to have it on your radar, because oftentimes a person will use a will as their primary planning tool. And maybe for their spouse, they provide for a credit shelter trust for their spouse's benefit when the first spouse dies, or they provide for trusts for their children when both spouses are gone, or if it's just a single person, when that person's gone, they have trusts under their will for their children or other beneficiaries. A testamentary trust is basically just a trust that's created under the terms of the will, meaning doesn't have a standalone trust agreement. It's not funded during the person's life. It's something that when I die, if I have a trust language under the terms of my will for some beneficiary or another, that's a testamentary trust. Okay. One question that comes up relatively frequently, as you can imagine, is what if there are assets in another state? Now, this really comes up for real estate, because if you own a bank account, it's not technically located in Washington or Oregon or Idaho. It's not state specific. So it's administered as part of your Washington estate if necessary. But when you own real estate in another state, so say, for example, I had a house in Oregon or Idaho or any place that's not Washington, and then I die owning that real estate, oftentimes an ancillary probate, which is an abbreviated form of probate, is going to be required in that state so that I can transfer title to my Oregon house to my beneficiaries, or rather my executor can transfer title to my beneficiaries. So what happens is very state specific. Some states, like I just recently learned this, Hawaii, for example, if you own real estate there, you don't have to do technically an ancillary probate. They will recognize essentially your authority as an executor in Washington to administer the real estate in that state. So each state is different, but it's one thing to have on your radar if you are either doing your own planning or you're thinking about, or you're appointed as a executor or a personal representative for someone else, is making sure that if they do have out-of-state real estate, you check in with that state because you're going to have to administer that real estate to get it into the name of the beneficiaries after death. Some overall tax considerations. And again, this is something that comes up whether you go through the probate process and have an estate using a will or intestacy, or if you have a revocable trust. You don't skate in either of those scenarios on the taxing authorities or potential taxes owed, so to speak. So federal and state estate taxes, Washington has its own estate tax. So if the decedent dies with over $2,193,000, there's going to be a requirement in Washington that an estate tax return is filed with the Department of Revenue. The federal estate tax exemption is significantly higher right now. It's 12.92 million. So if you die with more than that, if the decedent dies with more than that in assets in their estate, then a federal estate tax return is going to be required. We'll talk more about some of the requirements and timing and what that looks like here in a minute. But I just want to flag for you kind of the three taxes that really come into play when you're dealing with a decedent's estate. One is estate taxes. I just mentioned that, both federal and state. So keep that on your radar. Second, final individual income tax return for the decedent. So we all file our 1040s every spring, or if we extend, we file in October. So similarly, if I were to die today, my estate, my personal representative would have to file a partial year. My final income tax return would be for tax year 2023. And when is that going to be due? In April of 2024. So that is something to have on your radar in terms of, okay, I have to make sure that I file the deceased person's final income tax return. Similarly, if there is income inside of the estate, and this is specifically for tax purposes, income as defined in the Internal Revenue Code. So say, for example, I have a rental property and I die. Well, then my estate is going to have some income from that rental property because my tenants are going to continue to pay throughout the administration of my estate. So in circumstances like that, my executor would have to file a Form 1041, an income tax return for my estate. So those are three types of tax returns that should be on your radar as an executor. Similarly, if the decedent died utilizing a revocable trust, and a probate isn't necessarily required, there's still trust administration required, and there is still a requirement to pay and file, or to file and pay any associated taxes that are due. So kind of outlining what those specific taxes are, to kind of keep them on your radar and figure out, okay, what does this actually mean? Because estate tax is something that I think is a term that we often hear either in conversation with a neighbor or a family member or wanting to avoid estate tax. What is it? It's a one-time transfer tax that's due as a result of the decedent's assets rising to a certain taxable level. Again, in Washington state, if the person dies with over $2,193,000 in assets, that includes everything: life insurance, bank accounts, investment accounts, real estate, retirement accounts, everything. All those assets total, if they're more than $2,193,000, a Washington estate tax is going to be required to be filed. Similarly, for the Fed, if the person dies with more than 12.92 million in assets, reporting is required. So even if it's a circumstance where I leave all my assets to charity, so there's not going to be any tax due, my estate still has a reporting requirement if my assets total more than those threshold amounts. And this is just a little table that shows that the federal estate tax can be from between 18% and 40%, depending on the size of the estate. And Washington is from 10% to 20%, depending on the size of the estate. So let's talk about a couple of deadlines that we want to be cognizant of when we're dealing with a probate of an estate or when we're dealing with a trust administration. Now, if I die and my primary tool is a will, my executor is required to file that will with the court within 40 days of my death. That's required under the statute, even if I only have a Buick and a base fiddle and there's no probate requirement. So at death, one of the first questions to ask after you get that death certificate, and is, you take time to grieve, don't get me wrong there, but one of the questions from a administrative perspective to ask at the outset is, okay, do I need to file the will with the court? And the answer is, if the deceased person had a will, it needs to be filed with the court. Worry about opening the probate after the fact, that's fine, but you need to file the will within 40 days per the statute. One of the other important deadlines, again, regardless of whether you're going through the probate process or the person who died has either a trust or they only have non-probate accounts or otherwise, is making sure that you give notice to creditors. Because part of the administration process, either in probate or outside of probate, is when a deceased person dies, their debts don't automatically go away. And there's a 2-year window within which creditors can come after recipients of the assets or the estate if the assets haven't yet been distributed, unless we give proper notice. So what we do as part of administration, either in a probate or outside of probate, is we give formal notice to creditors, because what it does is it cuts creditors off at the 4-month window. So we publish notice to creditors, then they only have 4 months to bring their claim and they have to do it properly. Otherwise they can't get paid. Whereas if you do nothing, then there's a 2-year window within which they can come and file a proper claim, and then they're due, the debt of the decedent. Similarly, if there are known creditors, meaning, so for example, I die and I have a American Express card, or I have a Comcast account, or all these things that most of us, have in our everyday lives. Most of us have a credit card or, some type of line of credit that we operate on, or an account where a bill becomes due, like Comcast or a Verizon bill, similar. What happens is, at my death, the executor should publish notice so that that cut off creditors within that 4-month window. But if there are known creditors, like my executor knows I have an American Express card because my bill came in the mail, then those creditors are given direct notice and they have a 30-day window within which to act. So there's some timing of filing and publishing notice to creditors to give unknown creditors a 4-month window. And then at month 3, we'll oftentimes give direct notice to known creditors because they get 30 days and that cuts everybody off at the same time. So 4-month window, 3 months in, we give direct notice, and then 30 days later, you're at that 4th month for the unknown creditors, and you're at that 30th day for known creditors. So within that 4-month period, the creditors either have to speak now or forever hold their peace because they're cut off. Similarly, filing an estate tax return, if there is, now that's the transfer tax return. If the assets are over that $2,193,000 amount or over $12.92 million, the estate tax return is going to be due 9 months from the date of death. You can get an additional 6 months as an extension if you properly extend. You just have to file a request for that. Similarly, filing income tax returns, those are on a deadline, April 15th, just like for you and I while we're living, or October 15th if it's properly extended. Those are the tax deadlines for the decedent. So in the year that they died, depending on what part of the year that is, you may need to file their prior year's return for that year. So for example, say I died in February and I hadn't yet filed my 2022 income tax return, well, my executor would need to do that. And if I had income between January 1 and whatever date I died in February of 2023, the executor also needs to file my income tax return in 2024, April. So there are some deadlines that we need to kind of be cognizant of. I want to touch on a few miscellaneous terms that folks sometimes will ask about, because any Google search of probate or estate administration, et cetera, oftentimes there are a couple things that come up. And I just want to kind of give you an idea of what these things are so that you know what they are. A transfer on death deed, for example. In Washington, several years ago, we have had new legislation where we can execute a transfer on death deed. And what happens is basically, say I own a house in Seattle and I want to transfer that on death to my one and only child. And so I execute the transfer on death deed to Susie Q, my imaginary child, and then it gets recorded. I still own my house during my life, but at death, that house automatically vests in Susie Q. So that house doesn't have to go through probate. However, as we said at the outset, avoiding probate isn't the end all be all in Washington. And some issues can arise unless it's part of a comprehensive plan. So for example, if I die and my only asset is my house, but I owe creditors, or, I have, say I have $50,000 in credit card debt or other creditors, doesn't make me a bad person. It just means I've got some debt. Well, when I die, if my house is automatically transferred to Susie Q, there's no liquidity in my estate. So then Susie Q is going to have to come up with the cash to be able to pay the creditors or sell the house and then come up with the cash. And selling a house as an individual versus selling a house as an executor is different. There are things that are warranted by an individual seller to a buyer, promises essentially that you're making, that aren't required of an estate. Because as you can imagine, most executors never lived in the deceased person's house. They're usually a family member or a friend that didn't live there. And so you want to be careful of utilizing that as a tool to make sure that it really does fit with the overall plan and is appropriate as a means of transfer. Similarly, there are, it looks like, okay, I'm just looking at the Q&A here for a second. I'm gonna make sure that I didn't miss any. I have a couple here. Okay. Okay, so these are some really good ones. So I'm going to go through a couple of questions. Let me finish my thought here. With respect to the transfer on death deed, if you're going to utilize that as part of your plan, you want to just make sure that it's something that fits properly and appropriately with your overall circumstances. It's not simply, oh, I would like to avoid probate and I'm going to use this transfer on death deed to do that. It needs to be more thoughtful than that, is my only point. So a couple of folks had some good questions. So let me go to some of the questions and then we can kind of close out with some closing remarks. So what if you want to donate a home to charities? One of which is a library. Great, thank you, anonymous attendee. To avoid complications in probate, kind of what do you need to know about that? How much does the executor need to be involved? In circumstances like that, what happens is the executor does all the other tasks that they're required to do. They make sure that they give notice to your creditors. They make sure they identify the creditors. They list and sell your house, depending if the charity wants to receive the house in kind, meaning they want the actual house, or if they want the proceeds therefrom, then the executor can get a real estate agent, list and sell the house, transfer the proceeds to the charity. Or if the charity says, which this would be unusual, but if the charity said, no, we do want the actual piece of real estate, we want to own the house, then the executor can execute a quitclaim deed or personal representative's deed, transferring the house to the charity. So the executor still has to do their other tasks, meaning make sure that a tax return's filed if it's required, make sure that final income taxes are paid, make sure creditors are given notice, and then the executor can transfer the property to charity. Similarly, if they transfer the property to an individual, it just so happens that by transferring to a charity, you get a tax benefit, meaning that you wouldn't necessarily, it reduces the overall taxable estate if that's a concern. Are joint accounts and POD accounts transferred outside of probate? The answer is yes, if they have beneficiaries designated. So if there is a pay on death beneficiary, or if there's a pay on death or transfer on death beneficiary listed, then those accounts will transfer outside of probate just by providing a death certificate. Okay. Okay, some of these things are related to specific circumstances that folks are running into either with their probate attorney or their neighbor's situation. So those I'm not going to be able to answer today because they're more, they require a more specific answer and some real specific details that I would need to know. Great question. Must my executor live in Washington State? The answer is no. As you can imagine, we're very much global people, and your executor does not have to live in Washington State. And what they do need to do is when they open probate, they would appoint a resident agent. My clients do this often. I represent a lot of clients that are serving as executor but live in other places. And we file what's called a appointment of resident agent. They appoint me as a resident agent. And then that just means that if someone wants to sue them, which doesn't come up very often, if someone wants to sue them, then I can accept notice for them. What happens in Washington if a decedent has a will they drafted prior to moving to Washington and didn't have an updated will when they died? It depends. Washington does recognize wills from other states that were properly executed under that state's law. And so in most circumstances, it can be probated very similar to the way that it would be probated in the original state. What I tell estate planning clients, though, is if they move to another estate, to have a local attorney review the document before death, if you have the luxury of doing that. However, if somebody moved here and has a valid will in another state, it can get probated. But if you are on the planning side of that, making sure that it comports with Washington law can make things a bit simpler. A couple of other items that I wanted to call out just in terms of, like I did with the transfer on death deed for real estate, is a couple of other circumstances or kind of phrases that may come up in a search for you. And this, one of the questions in the Q&A is, what circumstances require a probate being opened? And that's a great question, because not every single decedent and not every single estate requires a probate. So say, for example, the decedent has no real estate and their probate assets are going to be under $100,000, then there's not a probate requirement per se. So what we do in those circumstances, or what you can do in those circumstances potentially, is use a lack of probate a small estate affidavit, meaning no real estate was owned by the decedent and the decedent's probate assets are under $100,000. Lack of, or a small estate affidavit. That's what that is. And that comes up sometimes, like if somebody dies and they had they had an investment account that was under 100,000 or a bank account that was under 100,000, but it didn't have a beneficiary designation on it, and they didn't own any real estate. And so what the family or what the heirs can do is utilize a small estate affidavit. Small estate meaning there is no real estate and the assets are under $100,000, and then go to the bank or the financial institution and get the funds transferred accordingly. One caveat there is I don't usually utilize those, and I'll tell you why. Banks can be picky and finicky, and financial institutions in general do what they want and require what they want. And I have had circumstances where under the law, an individual died, didn't have real estate, and had less than $100,000 in an account. So they would fit the bill, they would fit the profile of being able to use the small estate affidavit, and the bank wouldn't accept it. So we had to turn around and petition the court to get one of the heirs appointed as the administrator anyway, in order to get those funds released. I'm not saying that was appropriate on the part of the bank, but when those things happen, you want the path of least resistance. And because financial institutions are most familiar with probates, because they come up, as you can imagine, way more frequently than the use of those small estate affidavits, sometimes it can cost more to try and do step A as a small estate affidavit and then come around to step B and ultimately open a probate anyway. Similarly, if from the outset, whether you utilize a small estate affidavit or draft the petition to get the probate opened, transfer the funds, and then close the probate, there's some work to do there. And so you might not necessarily be saving yourself time or expense doing a small estate affidavit versus a probate. So there are a couple of reasons, and as you can probably tell, I would say in those circumstances, better safe than sorry. I would just open the probate, transfer the account, and close the probate because it's not a problem and it's oftentimes can be more efficient. Please discuss situations where probate is mandatory. So that's kind of the flip side of what we were just talking about. If you have real estate that's owned in your name individually, if the decedent has real estate owned in their name individually, or if they have over 100,000 in assets that need to be transferred because there's not a associated beneficiary designation or the assets not jointly owned, then a probate's going to be required to transfer those assets. Do social security numbers of beneficiaries have to be provided in the will or trust? No. That's a great question. In drafting a will or drafting a trust, those types of sensitive details, social security numbers, are not included. When social security numbers become important or you utilize them in either estate or trust administration is after the decedent's death. If there's a tax return that's required, an estate tax return, then we have to list who is receiving the gifts under the will or under intestacy. And then there's a reporting of the social security number associated with the beneficiary. Similarly, if you have a testamentary trust, remember that's a trust that's housed under the terms of the will. So after the decedent dies, and then you're setting up a trust for children or spouse or otherwise, then you will utilize the beneficiary's social security number in setting that up. But it's not something that is found, that number is not published in the will or in the trust or otherwise. That there's not a reason to do that. Oh, this is a great question. If I want to provide for the library in my will, should I tell you ahead of time, or is it better for charities to be surprised? I always say tell ahead of time, and that's for the library or any other charities that I do work with, because for the most part, these types of organizations, one, they want to thank you. They want to recognize you, not publicly, but they want to be able to thank you for your gift. Similarly, it's helpful for them in terms of kind of their tracking and internal mechanisms. And I'll let Kira and Jessica comment more on that. But what I always tell clients is, yes, make your charities aware that you're going to remember them under your estate plan. Does the executor need to report to the court when he or she distributes assets or pays a debt? So that's a great question. So typically, folks under the terms of a will, when they're appointed as executor, typically the court is, or the will is going to waive intervention of the court, meaning the executor doesn't have to get permission for every single task that they complete. They go to court, they get appointed, and then they are off to the races. They're able to administer the estate. They can sell the house, they can distribute the house, they can distribute proceeds, make final distributions. And then at the end, they file their notice of completion or their declaration of completion saying, hey, court, you appointed me as the executor of this estate. I've given proper notice along the way to the beneficiaries and the powers that be. I've done everything right. Now here's my declaration of completion. Please close this estate. So that is kind of a time when that quote unquote notice is really given, but it's not along the way with each distribution, et cetera. Now, sometimes an estate will be opened. It does require court intervention, either because the parties don't get along or the will, for whatever reason, doesn't grant non-intervention powers. That's very rare. And in those circumstances, then the executor does have to get permission from the court for each of those tasks that they want to fulfill. But that is very, very unusual. Oh, great question. I live in Washington. My child lives in California. If I appoint that child as executor, is the will still administered under Washington law? Yes. The will is going to be administered under the law of the state that the decedent resided in. So in that example, Washington. Are either probate or non-probate assets or both published anywhere for scammers to know about? That's a really great question. There's not a quote unquote like list of assets that gets published anywhere, but there is, when you file the will with the court and you petition the court to become the appointed executor, that is essentially public. Meaning if someone wanted to look in the court file and see who was the executor of Mr. Smith's estate and what did Mr. Smith's will say, they can see that, but that doesn't really give them all the information that they would need as to quote unquote scam. There's not account numbers typically included under the terms of a will. There's not sensitive information included. It's just a matter of, we would know the decedent's address potentially, and who was appointed as the personal representative. But, bad actors are going to act badly, really kind of regardless of that. But under the circumstances, for the most part, there's not a list of assets, so to speak, that would be published that would, give a bad guy a heads up that, Tiffany Gorton had an account with Chase Bank or similar, and here's the account number, nothing like that. Okay, so we have just a couple minutes left. And I'm going to look through these questions just here quickly. Can you confirm that if you leave your estate to charities, there's no federal tax and no Washington state estate tax? That is correct. If you leave everything to charity, even if you have $1 billion, if it's all going to go to charity, there's not going to be any tax due. There's going to be a requirement to file an estate transfer tax return to report that this person has died, they had $1 billion, and the assets are flowing to ABC charity. There's not going to be any tax due. To which court do you file the will and how do you do so? Great question. So typically in the county where the decedent lived, because they often owned real estate there as well. You can open probate in any county that you want, but typically it's going to be in the county that the decedent lived in. And the filing procedure you can find with the local court rules, and they'll kind of direct how you go about that.
Hi, Tiffany.
Okay. Yes.
We're back.
Thank you.
No one wants to hear from me and interrupt this. Thank you so much, as always. We really appreciate doing this with you. And also, thank you, everybody, for the incredible amounts of really thoughtful questions. I'm sorry to have to wrap up with you, but I promise we do make a lot of information available. I just want to remind you about, before you don't sign off, please allow yourself to be prompted by our very quick survey. And filling it out really does help us to make sure that, for one example, is we're trying to do the housekeeping really quickly, hearing from all of you who want as much time as possible with our presenters like Tiffany. And also just remember, fill out the survey and you will be entered into a drawing for some really amazing bag of books. We will be sending that follow-up information with follow-up email with the links to this recording as well as other goodies. So look in your inbox for that.
Thank you, Jessica. And thank you so much, Tiffany. I'm always amazed at how much I learn, no matter how many of these we host. There's something new every time. And as we said, Tiffany is generously curating a year-long series for us. So look for information on webinars coming soon in August, which is Make a Will Month, and November. We'll have information out to you about those about a month ahead of time. And finally, we hope that you know that a charitable bequest is one of the most meaningful ways that you can support the nonprofits you love, including the library. And going back to that question that Tiffany answered, we do want to hear from you. We love being able to say thank you for this very special gift that is including us in your legacy. So please do share your plans with us if you're comfortable. And remember that we're here as a resource too. We can help you. Our libraries have a lot of resources as well, and we can help point you in the right direction. So Jessica's information and my information will be on screen shortly. Tiffany can be reached at KHBB Law. We'll include information on contacting her in the follow-up emails. And in the meantime, stay cool, and we'll see everyone on August 15th. Thank you.
Bye. Thank you.
Thanks, Tiffany.